What does it mean if the defense is badgering our witness? Would you like to know the answer? Come join me for a walk as I walk the dogs. Hi guys, there's Bentley and Daisy, as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. It means that the defense is badgering our witness. So what does that mean? It means he's not being very nice. It means he's being antagonistic. It means he's being annoying. It means he's asking questions that really are disrespectful. Now, what do I mean? There are many different ways to question a witness, whether it's during a deposition, which is a pretrial question and answer session that's given under oath that takes place years before the case gets to trial, or at trial during cross-examination. And there are many different strategies on how to question a witness. Some attorneys will be very aggressive, and they want to show the judge, they want to show the jury that this witness is less than credible. And some attorneys think that the only real way to do that is by being nasty, aggressive, obnoxious, and many times being totally disrespectful. And by doing that, they think that that is going to show to the jury that this witness is being unreliable, that this witness is not credible. In that instance, I have an obligation to stand up and to yell out, "Objection, Judge!" The defense attorney is badgering my witness. In that instance, the judge has one of two options. He can either agree or disagree. If he agrees, you know what he does? He says to the defense attorney, "Okay, stop badgering the witness." That's what he does. That's the full extent of it. The attorney doesn't really have to do that. You want to know why? It's because everybody in the courtroom knows it. Everybody in the courtroom sees what's happening. If the attorney recognizes it, I guarantee you that if this is taking place at trial, the jurors see it too. The judge will see it too. The real purpose for the attorney making this objection is to try and put a stop to it. Another strategy that tends to be very effective is not to take such an aggressive attitude, but rather to poke holes in the witness's testimony. I've seen some of the best trial attorneys do that by being very nice and very polite. You might be somewhat surprised to learn that some of the best trial attorneys in the business handling medical malpractice cases and accident cases and wrongful death cases can actually be polite to an opposing witness. Let's say it's a medical expert who now is coming in on behalf of the doctor who is being sued. Some of the best attorneys I have seen are so overly polite that they destroy the witness. Why? Because they poke holes in his story. They poke holes in his testimony that he's already given. They show to the jury, without being nasty, without being aggressive, that what he is saying is simply not credible. And to me, after doing this now for 35 years, I think that's a much more effective strategy. On the other hand, there are some very good attorneys who at times will go ahead and take an aggressive approach with a witness that might appear to be badgering. You walk into a courtroom where this is going on, many times you can actually feel the tension in the air. You can cut it with a knife. That's how thick it is. I have seen cross-examinations where I've walked into a courtroom and the attorney is doing such a remarkable job in asking rapid-fire questions, aggressive questions, nasty questions that clearly show she doesn't believe a single thing this witness is saying, to show to the jury that this witness cannot and should not under any circumstance be believed. Now, the defense attorney or the opposing attorney could certainly jump up and yell out that the attorney is badgering the witness, but that has very little effect. If the defense attorney or the opposing attorney yells out, "Judge, the attorney's badgering my witness," the judge, if he agrees, turns around and says, "Okay, just stop doing that." So now the attorney will take a different approach for a little bit of time and then most likely go back and revert to being aggressive to again show that this witness has no credibility whatsoever. So the mere fact that the attorney points out the obvious, that the attorney is being aggressive and nasty and disrespectful to the witness, is that going to change or alter anything? It might for a few moments if the judge agrees, if the judge simply says, "Move on, counselor." And now there's nothing to say that the attorney can't continue that aggressive tone, that aggressive nature to showcase for the jury and the judge that this witness simply is not credible. So why do I share this quick information with you? I share it with you to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you wanted to see the dogs going for a walk. No, I realize you're watching this because you likely have questions or concerns about your own matter. If you have not yet started a lawsuit and are thinking about bringing a case and still have questions that need to be answered here in New York, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fascinating day.